The Honourable Simon Bridges.
Chair, I just want to deal with the points made, hopefully very briefly. The phrase, of course, there in clause 3, remove any doubt. I understand the points that are being made. In one sense, you could say quite strongly and persuasively by the member from New Zealand First. But I think if experience, and certainly legal experience and interpretation, teaches us anything, is that there is a requirement, and say so, and I'm not in any way casting aspersions on the member, but for a certain amount of humility in these matters, because laws, parliaments do make mistakes. And I think in a situation like this, where there are one, albeit most important piece of legislation, but other ones following that therefore adds some complexity, we need to deal in the realm of best legal arguments, most persuasive legal arguments. There will always be doubts, and good lawyers indeed in this traffic law area, they can create them, believe you me. But we felt on the basis of robust, poured over legal positioning on this matter that we took very seriously indeed. The government, and I'm grateful, I think the Parliament needed to act to ensure public certainty, and that speaks to the retrospective nature of this bill, which I'll come to, but also public safety in this area. And the crux of the issue is, I think, as both David Parker and Dennis O'Rourke have made clear in this House, a 2002 Local Government Act, then really a cascade of laws post that effectively set up a bylaw regime for councils. And at one level, and this is where I go some way with Dennis O'Rourke, the responsibility on councils had some clarity. Ultimately, they were to pass bylaws for their speed limits, and they were to review them in a 5-year period, actually a 2-year period of grace after that. And in Kapiti District Council's case, we certainly know that didn't happen. But I would say, as I already said, there is a need for, I think, for a degree of humility in these issues. We are dealing with legal arguments. They can go other ways, but I don't think the government or indeed this Parliament could leave it to hang on that when we had a body of clear views that said we would be putting public certainty and certainly public safety retrospectively and prospectively into jeopardy. I just want to deal with the retrospective aspect of this legislation briefly. I wasn't here for Russell Norman's speech, but I gather from other members' contributions some concern about retrospective legislation. I think we can all say, whether we're legally trained or not, that it's quite clear that retrospective legislation, all things being equal, is undesirable. Indeed, it can be a breach of the New Zealand Bill of Rights Act, and we need to take those sort of issues very seriously indeed. There are, though, times when retrospective legislation is necessary, and where this Parliament rightly reserves the right to pass such laws. And I think here we're not dealing with just one, but a number of reasons that make it very clear that retrospective legislation is on balance, and having considered all of the alternatives, the right thing to do. First and foremost is public safety. And there is no question we cannot have a position where there is some doubt, we've used those words in clause 3, any doubt, that someone today can in Kapiti Coast go at a much faster rate than the speed limit we thought was the case. That would be unsafe, it would be putting lives at risk, and it would be the wrong thing for us to do. And that is a strong reason to be retrospective here, to clear that up for the past and for the future. I think the other reason is also very clear in this. This is not a matter where anyone has acted in bad faith. This is a matter where very clearly, again, if we take the Kapiti District Coast, the signs, the police, the public of that area all thought the speed limits were a certain way. Everyone thought the law was that. Not only that, I would say most reasonable people throughout New Zealand thought that that's what the laws and the speed limits should be. So it's what they thought they were, and it's what they thought they should be, and that's what right-thinking people would think in that regard. So we are, and this is a clear area where retrospective legislation is appropriate, going back and technically fixing what might otherwise be not correct and unsafe, but in a position of good faith.
Point of order, Jane Hayes.
I seek leave to have part 1 and part 2 be taken as one question.
And all parts, including clauses 1 and 2.
Yes.